Good afternoon, everyone. Live as if we were to die tomorrow, learn as if we were to live forever. With esteemed guest speaker and all the ever learning, ambitious founders and innovators for yet another masterclass day on this warm Friday afternoon. This is the second session of Samunnati Masterclass series, a 5-week series aimed at assisting agri-tech and food tech startups to become ready for the market. All new aspirants can watch the previous sessions streamed on Samunnati's YouTube channel. I am your host and moderator Anupriya. Thank you for taking the time to join us today. Now, I call upon Mr. B. Gopalakrishnan for the welcome address and contact setting. Welcome, sir.
Hey, good evening, everyone. Let me introduce myself. My name is B. Gopalakrishnan. People call me BG. I'm the head of Samunnati Startup Initiative. On behalf of Samunnati, I once again welcome you, everyone, for this online masterclass series. This is a 5-week series wherein we are just completing the second week. And the primary ambition to assist the agri-tech and the food tech startup to become market ready. Samunnati is an open agri network to unlock the $1 trillion plus potential of Indian agriculture with smallholder farmers at the center of it. Samunnati works closely with agri-tech startups in providing both non-financial and financial service. Our pillar of engagement deeply focuses on founder development, market readiness, and investment readiness of the agri-tech startup. As a part of our continuous engagement, we are hosting this masterclass series, a unique series which has been curated by the startup agri-tech startups and with a theme of winning big with dreams. The purpose of the masterclass series is to provide curated seminars, panel discussions, and boot camps for agri-tech startups to gain knowledge, skills to be applied in realizing the true market potential. So before proceeding to the session, the importance of the protecting the idea, which is very, very crucial. So you must be known, Steve Jobs, the man who is the CEO of Apple in 1976, along with Wozniak, they started this company. In 1985, Jobs was asked to leave the company. And there are some amount of problem within the board, and he has started another company. And 1995, again this board has called them. 97, they call back Job, and after that the history has been created in Apple. So why I'm telling, there are many times when we talk to founders, co-founders. They all say that, okay, we have a trust with the co-founder, I have a trust with the people. So there is no co-founder agreement, or some of the trade product protection which has not been taken, some of the IP protection which has not been taken. So in the early days of your venture building, whatever be the nuances of protecting your idea, protecting your brand, protecting your trade, protecting your even a small idea, which is very, very crucial for you. So that is why the session 2, which is focuses on protecting your ideas. So we hereby begin the second session of masterclass as saying by Sanjo, guard your intellect like most valuable property you own. Today's session will awaken your awareness of one of the most valuable pieces of property you business, which will own its intellectual property to identify, protect, and profit from your innovation. So there are numerous case studies which is available from the founder to founder. If there is a co-founder agreement which was missing for one of the startup which we are mentoring them, and finally, whenever there is an investment which is coming, the co-founder was not ready to accept the investment. He's saying, "Sir, I don't want to take any money out of to my company." So please ensure in the early days, understand the full nuances of protecting your entire venture, not only with respect to IP. What are the crucial component of your venture details has to be protected. All these things we will be understanding from the today's discussion. So thank you once again for joining. And let me go back to moderator Anu. Back to Anu.
Thank you, Mr. BG. So the question is, not today is not whether you have an IP. It is whether you know how to use your IP. All curious entrepreneurs, here's a call to you. You can use the Q&A box feature to register all your questions. Your questions will be answered by the end of the session. Now, it is time to welcome the guest speaker of the day. Knowledge is a very vital in life's transformation and transition. So, without further ado, I would like to invite our most knowledgeable and experienced intellectual property strategist, speaker of the day, Ms. Akshaya P. Sachin, partner at Kriya Law, specializing in infringement analysis, trademark prosecution, and she has 8+ years of experience working with leading intellectual property law firms in Asia. During the course of her career, Ms. Akshaya has individually handled trademark portfolios for her clients across 140 countries by working closely with local councils around the world. She has conducted large-scale intellectual property audits for compliances and protection of intellectual property. She has also assisted numerous clients with brand availability opinions and drafting and vetting of agreements specific to intellectual property, such as trademark license agreement, confidentiality agreements, and franchise agreements. Now, I welcome Ms. Akshaya to share her thoughts.
Thank you, Anu, for the introduction, and thank you, Gopal sir, for setting the right context to this seminar. Good evening, all participants. I'm sorry, I'm having some technical glitch, so I'm unable to switch on my video. I would like to thank Samunnati for this great opportunity and for everybody for this upskilling session. I hope it would be a great and informative session for all of you to understand what is intellectual property law, what is the basics, and how should we go about protecting it, and what are the essential compliances with respect to the protection of intellectual property is what I would be covering during the course of this seminar. So I'll just quickly take 30 seconds to share my screen. So before we go about understanding what are the different types of intellectual property law, I would like to take 30 seconds to define what is intellectual property law. So intellectual property is basically anything that is creative, anything that is created by the mind of a human being. So intellectual property can be a new invention that we come about, or any new brands that we have, or a new book that we write, so on and so forth. So basically anything that is created by the mind is what is defined as an intellectual property. So there are different types of intellectual property. First, we need to understand and get a clarity, because very often these terms are used interchangeably by many parties. I've had many clients who've come and say, Akshaya, I've come up with a new invention which is totally new. I have not seen anything like this. I would like to trademark it. It's actually subject matter of a patent and not trademarks. Similarly, I've had people who've come and say, hey, I've written a very good book. I would like to trademark it. It's subject matter of copyright and not trademark. So it is very critical to first understand what are the different heads and what falls under each of these heads. So let's start with the most common and the most sought after and a very easy understandable IP, which is trademarks. So what is a trademark? A trademark is basically the face of an organization, which is the brand. What you face, how you identify your business, your service is what is a trademark. I will be dealing with each of these IP in a much more elaborate manner in the next minute or two. This is just for us to understand what comes under each bucket of IP, just an overarching view. the patents is the most important and the most widely sought after intellectual property, which is something that we invent as an invention, or something which is new, something which is novel. So for example, in the agri-tech, a new seed sowing machine which goes in depth and digs the soil in a much in-depth way, that is a new invention when it comes to the agri-tech sector. Industrial design is the next IP, which is basically the aesthetics of a product. So anything that appeals to the eye, or anything that looks pleasing, which has a new shape or a design, is covered under the industrial design IP. And then comes copyright. Copyright is basically anything that is in the written form, or even software for the present audience would cover under the copyright. Plant variety is a very relevant form of protection for the agri industry, because new different varieties of seeds and plant varieties can also be protected, which is an important IP for the agri-tech. Then comes the trade secrets. So anything that doesn't fall under the trademark or copyright or other earlier IPs which we've seen would cover under trade secrets. For example, Coca-Cola, their formula of how Coca-Cola is being prepared is still a trade secret. It's been a trade secret for several hundred years. Because if you file a patent for the formula, it will go into the public domain after 20 years. Whereas a trade secret has a perpetual period of protection. Therefore, your know-how and the formula will be protected for times to come without any expiry date. So that is the importance of a trade secret as an IP. And then comes confidential information. So you as a startup, you have a niche client list, or you've done a lot of research to find out who has requirements for the services that you are rendering. You've done a lot of groundwork into building up a portfolio for you. Such data would be considered as confidential information. So these are the broad types of intellectual property, and how each different aspect falls under a different head. So we will now understand in detail what each of these intellectual properties cover. So let's first start off with trademark. Like how I initially said, what is a brand? A brand is the face of an organization. So we identify ourselves through the brand. And how consumers identify us in a crowded market is through trademarks, is through brands. So we go to a supermarket, we know we have a special favorite brand of food that we like, or we have a special brand of soap that we prefer. All this is possible because of trademarks. If there are no brands, we wouldn't be able to identify a specific, we wouldn't have a specification or liking towards a particular product or a service. So trademarks can be of different types. It can be a logo, or it can be just a word. It can be a symbol, it can be a slogan, it can be a shape, and now with new forms, it can even be a smell. There have been instances where even smell and colors have also been protected as a trademark. So when it comes to trademarks, the biggest question is, how do we choose a brand? How do we go about finding the perfect brand for us? Because it's a constant battle between the marketing department and the legal department. We as trademark attorneys, we will always come back and advise startups to always ensure that we select a brand which is not identifying what you do, so that we stand out in the market. Whereas the marketing department will always advise you, hey, you have to ensure what you do is always there on your brand, on your business name, so that people know what you're doing. So it's always a constant battle between these two departments. But generally, the trademarks are divided into these 5 types. The left corner is the most generic brands. That is, it's generic words that we use. Hey, best, great, classic, super. These are all brands that are very generic in nature, and it is very difficult to protect. That is why it's in the fag last end. So we usually do not encourage startups or any organizations to adopt brands which are generic and descriptive. You can consider adopting trademarks that are suggestive, arbitrary, and the most usually appreciated and easy to protect brands are the inherently distinctive trademarks. The reason why we do this split and the recommendation is the reason for enforceability and uniqueness. So what does a brand give you? It gives you the exclusivity to use a particular trademark, which means that only you have the right to use the particular brand. So for example, if you adopt a brand which is descriptive, say for example, Cafe Coffee Day, it's just a cafe where they give you coffee and they've just added the word day. Cafe Coffee Day has been finding it really difficult to stop other third parties from using cafe and coffee together. Because in a cafe, what do you get other than coffee and tea? These are the only two. It's descriptive of what they're doing. So Cafe Coffee Day, Creamy Herb, these are all classic examples of a descriptive trademark. And the reason to move away and stay away from such descriptive trademark is, and as well as generic trademark, is to ensure that we have the right to stop others from using it. So tomorrow when somebody comes and uses herb cream, it's a herb which has cream, or it's a cream which has herb. So it is what the product is. So we essentially cannot stop them from using it, which degrades the whole purpose of the trademark. And then comes the suggestive trademark. A classic example of a suggestive trademark is Airbus. Airbus suggests what the product is, but it doesn't describe what the product is. Similarly, arbitrary trademarks are, it is a common word that is existing. The product or the service for which we are using it is completely different. Apple is a fruit, but Apple in relation to technological goods, in relation to phones, tablets, this is very unique. So arbitrary trademarks are also something that the audience could consider when you are looking at adopting a brand. The best and the most appreciated and easy to get a registration trademark is the invented trademark. We wouldn't have heard about the word Swiggy or Zomato or Kodak or Ola or Uber before these guys came up with these brands. It's an inherently distinctive and a unique invented trademark, which they coined by sitting together. So these trademarks are how your product or services stand out, and how it will be easy for you to get a registration as well. So this is how you should consider. But before you adopt a trademark, what is it that you should do? It is critical that you ensure that the brand that you are wanting to adopt is not similar to anybody else who's using the brand. So for example, I faced a situation where a similar startup who was incubated adopted a brand which was, they did not do a trademark search. And then 6 months from when they started, there was a notice that was sent to them where there was a prior third party using a very similar name with just a minor tweak in the trademark, and they had to change their name completely because of the notice. So before we go about and launch the brand, and before we decide this is going to be our company's brand name, it is absolutely critical that we ensure that we do something called a freedom to operate search, which can be done even by each of you. This is the IP India website. You just have to go there and select the public search option. And then here is where you can do the search to find out if there are any third parties who are using a brand that is similar to the one that you are wanting to adopt. So it is very important that we do this to ensure that we don't infringe anybody's rights, and then in the future the organizations that does not get into any problems. While going into the requirements for filing a trademark application, it's pretty straightforward. All we need is the name and address of who the applicant is going to be. What is the mark that you choose to file? What is the description of goods and services? So in India, we have about 45 classes under which all the goods and services are classified. So anything that is related to technological and agri-tech would fall under 42 and 9. So it depends on what goods and what services we are providing. So that description, anybody who is, you can check out with any lawyer, they will be able to guide you as to what would be the description of goods and what would be the date of your use and a power of attorney. So these are all the requirements for filing a trademark application. And India is one of the most fastest in granting a trademark registration. If all goes well, registration can, all goes well, I mean, if you have adopted a unique trademark and there are no trademark that are prior to you and similar to the brand that you've adopted, then it will be a straightforward acceptance. You will be able to get a trademark registration within 6 months. So we are faster than the US, we are faster than the UK, we are one of the fastest in the world. So if you are choosing the right brand, within 6 months, you will be able to get a trademark registration. So this is an example of how a trademark registration certificate looks like. Another most common doubt that is usually asked by organizations are, if I file a trademark application in India, is this valid across the world? Can I get a registration across the world? No. Trademark rights are territorial, which means that if you file an application and get a registration in India, that registration is valid only in India. If your business is expanding outside India, if you're planning on launching in the US, if you're planning on launching in the Europe or Singapore, you would have to go and seek protection individually in each of these countries. A classic example, because you would have to do this whole process of trademark check in each of these countries, because the check that you do in India is applicable only in India. There was a very Ford launched a SUV called Ford Everest a long back, some 20 years ago in the US. In India, the Everest was not available in the class that Ford was wanting to. So they changed the name to Ford Endeavour and launched it in India. But if you see the Ford Endeavour's back, they'll have the Everest, the drawing of Everest. So this is a classic example of the territoriality principle, because what might be the brand that might be available in India may not be available in other countries that you are wanting to launch or you're wanting to protect your IP. So another easy manner, this is not an international registration, but it is a system where by filing an application in India and opting through this Madrid application route, you can designate countries in which you want to seek a registration, and those countries will examine the trademark and grant you a separate registration. This is just a manner in which will give you ease of protection across the world. This would not be an international registration across all countries, but it's a easier way to register your application, your trademark in more than one country. And another very common doubt that everybody has is, when do we use a trademark? When do we use R? These two are usually confused, and these two are usually interchangeably used. A TM symbol can be used even without a trademark application. You can start using the TM symbol as soon as you come up with the brand. You know that this is going to be your brand. You don't have to wait for a trademark application. You don't have to wait for a GST registration. You don't have to wait for your bank account. You don't have to wait for anything. As long as you know this is the brand, you do your due diligence, you do the trademark search, you can start using TM. There are no statutory compliances or requirements for anybody to start using TM. However, the R symbol can be used only after you obtain a trademark registration. A few slides ago, I showed you the trademark registration certificate. Only after you get that certificate in your hand is when you can start using the R symbol. Before that, it cannot be used. Quickly, I will take you all through a few examples of very notable trademark disputes, just to make this an interesting session. So this is a very interesting case where a party from 1957 was using Dindikkal Talapa Katti biryani, and another party recently started using Talapa Kattu. They just changed TITTU. And Dindikkal Talapa Katti went against this party, and they were successful in stopping this party from using the brand Talapa Kattu. This is a case where there was a Archie restaurant which was opened in US. Archie Masala is a very famous masala brand in South India. So this US restaurant was there. Archie had successfully registered their trademark in US. So they were very successful in stopping this party from operating this restaurant, because people assumed that this was a restaurant that was started by the Archie group, and all the masalas that were used were Archie masala. Similarly, this is a very prominent case where Apollo, there were many Apollos that are coming up, and Apollo has been very aggressive about it. So there was a Sai Apollo which was started, and Apollo filed a case against them, and they were stopped from using a similar brand. This is a very landmark and an important case where Mercedes-Benz sued VIP, which is an innerwear company, because they used the word Benz and they used a logo which is very similar to the Benz 3-star logo. So Mercedes said Benz is a coined word, and because of the fact that Benz was a coined word and nobody has been using the word Benz, they were very successful in stopping VIP from using this for an innerwear brand. So this is also a recent case where there was a party who started using Daily Basket, and they were being sent a cease and desist notice by Big Basket, and this is a startup which was incubated in South India. So they had to stop using Daily Basket, and because they were conceptually similar, so they had to stop using this brand and they had to rebrand their products. So a quick takeaways in relation to trademarks are, please don't alter existing trademarks and say, hey, I'm using it completely. Is it okay if I use SWIGGI for watches? Not at all. You can't use different brands, the same brand for different goods or services, or make minor changes and use it for the same goods and services, or use descriptive trademarks, because it would be very difficult for you to stop third parties. I will quickly move on to another set of IP, which is copyright. So copyright is basically a collection of rights that will vest as soon as you create it. So for example, I take a paper and a pen today and I work on a small article, or I work on a story. Copyright in that story will automatically vest with me. I don't have to necessarily seek a registration. Registration is not mandatory in a copyright. It is very, it's a very unknown fact that you can assert copyright even without a registration. It is just a matter of you proving ownership. That is about it, in the sense that you have to prove that I am the author, I am the owner of this work. It is not necessarily that you have to go before the Copyright Office and have this fight. The most important form of copyright that is relevant to the present audience would be a software. So these are all different types of copyrights, which can be a literary work. So books can be copyrighted, dramatic works, musical works, cinematographic films, sound recordings. These are all different types of copyright. So software as a copyright is what is most relevant to the present audience. So how is software protected? Software is usually, the source code is protected as a compilation of literary work. So usually what we do is the source code, sometimes the source code runs over hundreds of pages, and the company may not be willing to disclose all the source code. So what we do is we file the first 10 and the last 10 pages of the source code. And then that is protected as the copyright. Then comes the ownership with respect to the software. So what happens when a software is created is there is an automatic right that will vest to the creator of the software. So if I, as a company, engage a third-party developer to create a software, what happens? The developer who is creating the software will have the right, he will be the author of that particular software. So in order to ensure that I, as the company, become the owner of that particular software, it is critical that we get into agreements with each of the people, each of the developers, or if we have employees who are developing these software, to ensure that the ownership in that copyright, in that software that is being created for the company, the ownership is transferred to the company. there have been several cases, including cases where there was a employee who created a software for a company, but the company did not get into an agreement, and there was some default of payment by the company as well. So the employee filed a case claiming rights over the software which was being used by the company. And the courts, after looking at the lack of agreement and lack of payment to the employee by the company, held that the owner is in fact the employee, ex-employee, and not the company. And the company had to pay a huge amount to buy back or buy the software that was created by the employee, in fact, for the company. So it is critical that these are the small things that we tend to miss out on, but it will have a great impact in the future once we become big. So it is important that any third party who's involved in development of anything, including software or mobile application and so on and so forth, we get into agreements, we indicate that this would be a commissioned work and we would be the owner. This is an example of a copyright certificate which we've obtained for a software. So brand liaison, we would have to give them the details of what is the language of the work. So if you see there, it says HTML, JavaScript, and so on and so forth. We would have to give the title of the work and so on and so forth. Moving on, patents. What is a patent? I'm sure this would be the most important type of intellectual property for many of the companies here. So the patent is basically an invention which has a new and an inventive step which is capable of industrial application. So what you see on the screen is a patent which was given to toilet tissue paper way back in 1891. Which has the perforated holes. So way back, it need not be a complicated machinery which has a lot of codes and so on and so forth. It can be a very simple invention nobody has ever thought about. Paper clip at one point of time was a patented technology. Bell clips at one point of time were patented technology. Cloth clips were patented technology. So these were all things that nobody thought of until one fine day somebody thought about it. They came up to make our lives easy. So anything that is new, which has inventive step and is not existing in the market, is what is a patent and is capable of industrial application as well. So a patent is something that can be registered, provided it is not existing in the market. Once registered, the duration of the patent is 2 years. So patents can be either a process patent or a product patent. And the rights that are granted when we obtain a registration for a patent is a negative right, which means that we have the exclusive right to sell the patented technology or the patented product. So in that way, we have the right to stop anybody else for that 20 years from dealing with the patent, the process, or the product. So what is most critical and the most important takeaway or important point that each of you should note when it comes to a patent is patent cannot be protected if it has been prior published. The most big blunder that many people tend to do is they come up with something new, they go ahead and publish a paper about it, even before filing a patent. Or they send out a news article saying, hey, this is what we've published, this is what we are coming up with, this is what is the technology. So these are all suicidal things when it comes to a new technology, a new patent, because as long as it is not in the public domain, as long as it is not published, then the patent right can be granted to you and it can be protected. But once it comes to the public domain, once there is a patent, once there is an article published or so on and so forth, then it would mean that this is prior published. So one of the most important prerequisite for a patent is that it has to be novel and not published prior. So which means that even your own publication would be considered as a prior publication and you would not be able to obtain a patent. So when it comes to, if you as a startup are coming up with something that is new or novel and it has not been done anywhere in the world, it is critical that you file a patent first before you reveal that technology to an investor or to anybody else in the world. It is very critical because we have been facing quite a few problems and quite a few similar instances where startups are very eager. They come up with something very new, very novel, but they have gone ahead and published it. If they are incubated in universities, they've gone ahead and published it as part of the university paper, or they have disclosed it to the investors and they know what it is and they've gone ahead and shared it in the media and so on and so forth. So it's very critical that you, before you disclose it to anybody, please file a patent application. So these are all some of the examples of technology that has been done so and that's been protected in the agri-tech sector. So for example, there has been technologies to monitor crop quality, or for sowing seeds through drones, food processing technologies. These are all examples of patentable technology in the agri-tech sector. So moving on to the next form of IP is the designs. So there is a very often people get confused between designs and patents. So what is the difference between a design and a patent is a patent is for the invention, for the novelty of the invention, while a design is for the aesthetic, the manner in which a product looks. So as you see, this is the front part of the Land Rover was a very unique, they had a very unique mesh type design. So this, they had filed a design application and this was protected as a design. So even this small chair, which is, the cost really doesn't matter. If it's a unique design, that can be protected as a design. This may not be a very sought after form of protection unless your goods or the services that you are dealing with has pure aesthetic value attached to it. Another most critical and a very relevant form of IP in the agri-tech sector is the Plant Variety Protection Act. It is basically a protection that is granted to plant breeders to provide exclusive rights to a particular variety that a farmer has bred. So Indian farmers are being very creative and they are coming up with new different varieties of seeds, varieties of plants. And under this act, one can go and seek a protection for that variety to ensure that nobody else claims protection or exclusivity over it. So there can be different types of plant varieties that can be protected. It can be a new variety which is not there in the public domain at all, and you have come up with it entirely new by various combinations of drugs. Then there is an extant variety, which means it is a variety in common knowledge, but you have made some minor modification which has been developed by you solely. And then there is a farmer's variety. So there have been instances where a particular set of farmers have been cultivating a set of crops through traditional method, which only those set of farmers will know. Even that can be protected as a farmer's variety of a crop. And a derived variety is where you come up with something that is derived from an already existing variety. So like what can be registered, there are also a set of varieties that cannot be registered. For example, if it is going to be injurious to the health of a human being or any plants or any animals, or if commercial exploitation cannot be done by using the plant variety, or it is against public order, so on and so forth. So there are different types of this plant variety act. The knowledge about this and the enforcement of this variety act in India, the awareness is very low, especially in the agri-tech industry. I'm not sure if anybody here are aware of this, because it's a new act and the registration under this act is very little. But it is when there are new varieties of plants or new seeds that are being developed, it is encouraged that one registers under this, to ensure that we as a country also have a repertoire of different varieties of plants and seeds to get a whole sum of what is happening and the agricultural development in the country. So these are the different heads of IP that we've seen. I will quickly take you all through the most important compliances as a startup has to do when it comes to how do you start, how do you register, what are the different types of agreements that you would have to enter into, so on and so forth. So before I go on to the agreements, I would like to talk about the startup registration. So in India, there are numerous privileges and numerous perks that are being given to startups. If you are registered under the DPIIT startup scheme, you have concession in filing IP, you have tax holidays, so on and so forth. And the registration process is also very, very simple. So I have had clients who've registered and they've gotten the startup registration certificate within 48 hours. So the list of requirements under this the registration is also very simple. They just need your incorporation certificate, your contact details, who is the contact person, what is the description, how is your business unique from others, and what are the total number of employees. These are the basic requirements. There are not much. So you just have to go on to the website and fill in all these details and submit it. And mostly within 48 to maximum, I think they're taking not more than a week, you will be able to get this startup registration certificate. This is the example of a startup registration certificate. So with this startup registration certificate, you can get numerous benefits when it including you have a 50% reduction in the cost of filing trademarks, more than 70% reduction in the cost of filing patents. In patents, if you are registered under the MSME or the startup category, your process is also fast tracked. So the patent office ensures that they examine patent applications filed by startups in a much more faster way and on priority. And the DPIIT and each state government, they have numerous and substantial amounts of funds allotted for startups in India. Recently, I was in a conference where the startup moderator of the Tamil Nadu government said that they have close to 3,000 crores that are not being utilized, and anybody who's registered under DPIIT, please reach out to us. So that's the access of funds that you can get by being registered under the Startup India DPIIT scheme. And also a tax holiday. Startups don't have to necessarily file income tax for 3 years. And the Indian government is coming up with a lot of new and inventive R&D facilities and providing a lot of facilities for such startups as well. And it is apparent, and you will have access to numerous startups and other startups who you can work with symbiotic. You can have a symbiotic relationship, and networking is also a great skill that you can get. So coming to what is it that you have to do as soon as you incubate or as soon as you have an idea to start an organization with somebody. The first and the foremost agreement is a founder's agreement or a promoter's agreement. When you start a company, say with your friend or a relative or anybody you know, when you start off, things will definitely not look bad. It will always be rosy. Your ideas are new. You have a lot of energy in you. Things are looking great. It's all good. But 2 years down the lane, when you don't have enough funds, or you're not finding investors, or your idea is still not novel, and there are better ideas that are coming up, when things turn to begin to get sour, then you will definitely have issues when it comes to how the company's idea is taken forward. So in such cases, to navigate during such cases is where these founders agreement and promoters agreement come into place. It is critical that at the time of entering or at the time of inception of the startup itself, you enter into these founders agreement, which will have essential clauses such as what is it that each founder is expected to bring to the table, who has the deciding power, who has the deciding authority, who can say yes, who can say no. In case of a conflict, how do we resolve it? What are the things, who will get what percentage of the capital if we decide to dissolve the company? Who is the owner of intellectual property, which is being jointly developed by both parties? So these are all important clauses that has to be included in the founders agreement. Anything and any circumstances that you foresee that might require a written agreement is what is basically, there is no standard clause or standard template that one company can follow. It differs from every sector. So one company might have a various, if you are in the food tech, you will have a different set of requirements, while if you're primarily only in relation to agricultural products, you will have a different set of requirements, and so on and so forth. So every startup is requested to enter into this founders agreement to ensure that your future is in safe hands. The next most critical agreement is the non-disclosure agreement. So this is an agreement which you would have to enter ideally with all your investors and anybody to whom you are divulging or disclosing your ideas or your intellectual property. So, hey, you've come up with something new, you are going and pitching your ideas to 10 companies. Then I have seen in the past that investors are reluctant to sign NDAs. It is not very easy to get these done. But a very simple one-page NDA is something that it need not be very complexly worded or things like that. It can be a very simple one-page NDA which says, hey, what I'm showing you is you don't have right to share this with anybody else. That's about it. That's the crux. Basically, that's the crux of the NDA. So something like that has to be shared and signed with anybody with whom you are divulging your proprietary information and your intellectual properties. Then comes the employee contracts and the offer letters. So like how I mentioned during the copyright session, copyright slide, any work that employees do during the period of their employment, any IP that is created would vest with the employer. But this is defined primarily by way of an agreement. So it is important that we enter into agreements with each of your employees or consultants or interns or third parties, anybody who we engage to create anything for us, and ensure that all that they create belongs to you and you pay a suitable amount of money, and which is acknowledged in the letter as well. The employee contracts and offer letters are very critical because there have been many instances where employees come, you have a 6-month probation period where you do your training, you have a new technology, you've invested so much of money to and efforts to come up with that. They come, they spend 3 months, they get to know what it is, they leave, and then they go join a competitor and give them all the advantage. To avoid such situation to ensure that you don't have a great attrition rate, or your ideas are not being transferred to your competitors, it is important that you get into employee contracts which has a very strong non-compete, non-solicitation clauses in India. So this is the second set of agreements which I was talking about, is the agreement with consultants, manufacturers, vendors, and clients. So the agreement with manufacturers and vendors is also a very critical agreement, because say in the manufacturing sector, for example, there is a company that engages a manufacturer in China. They give them their molds. They manufacture all the products for the Indian company. China being China, what will they do? They take the mold, they do 10,000 more extra products, sell it as a cheaper rate to another competitor. So in such cases, to avoid exclusivity of your products, to ensure exclusivity of your products and avoid duplication, it is important that we have agreements with vendors and manufacturers, even vendors. So if you have an exclusive vendor, you tell them how to do it, how you share all your confidential information, all your trade tricks and everything. And then the vendor just understands, learns, and then he does the same thing for your competitors. So these are all problems that startups and every organization faces in the market. And these agreements, though if it's being watertight, it will definitely help you enforce your rights. So you can always say, hey, according to this agreement, you're not supposed to do it. If you're in violation of the agreement, you're supposed to give me 50 lakh rupees. So that penalty, that retrition would definitely have an effect on your vendors and your manufacturer, and it will avoid a lot of losses for any organization and not just a startup. I think I've overshot my time. I will just take 2 more minutes to wrap it up. The last, but a very critical advice that we often give to the startups is record keeping. Because when it comes to enforcement of your intellectual property, or to have a proper history of how your services are, your goods are, or how your organization has been growing, it is important that you have a record of everything. Because I will give you an example. When it comes to a trademark dispute, in India, a person who has first used a trademark has better rights. And anybody who is a subsequent user but a prior registrant won't have a use. So say, for example, I as Akshaya, I've started using Samunnati in say 1980. But Samunnati has started using Samunnati only in the recent 2000. I have proof that I've been using Samunnati from 1980s. Then Akshaya will be the better owner. So the proof, the collation of documents is very, very critical, not only for trademarks, but also for other compliances as well. So you would have to have nowadays it's very easy to store everything digitally. So having a separate folder for all agreements, you have a folder for agreements with clients, agreements with interns, agreements with manufacturers, so on and so forth. You can have a separate database for invoices, all the payments you make. Now getting data, getting storage space online is cheaper than having a meal. So it's critical that we save all these documents from the day one of your inception in an organized manner, so that all compliances, not only with respect to IP, but with respect to tax, with respect to labor laws, with respect to other forms of compliances, becomes easy, rather than you trying to scramble and find where is what, where is here, and so on and so forth. These are the most important benefits of having a good record keeping process in your organization. It definitely prevents a lot of fraud or theft of information. There has to be a lot of loopholes that can be prevented. If you start doing everything right from day one, if you have an organized manner of planning and working, it'll save a lot of time and cost at a later point of time. So with this, we come to the end of my presentation. I will now open up for questions. Yeah. So shall I
Thank
start?
you.
Yeah.
Yes, thank you, Ms. Akshaya, for sharing your knowledge and experience on protecting ideas with us
In
in
a very short span of time. So I'm sure that the participants would have realized the importance of how strategic use of the intellectual property can give a business several years of protected competitive advantage. Our
Thank you, Anu.
gentle reminder. Thank you. So now a gentle reminder for the participants. So the participants who are present throughout the session will receive a participation certificate from Samunnati, and the topic for the next master class will be announced at the end of the session, and a feedback form will also be circulated. So please stay tuned. With that, the forum is now open for Q&A session, and we'll go ahead and take some questions.
Yeah. So there are 3 questions that are here in the open question and answer. Are there sector-specific IP consultants, asked by Mr. Shushil Shekle? So, well, not really, sir. All IP practitioners, we practice across all sectors. So I, in my about 8 years of experience, I've had clients in pharma, in media, in alcohol, in health, in so on and so forth. So it is not specific to any sector. We will be able to assist you across all sectors. Having said that, when it comes to patents, I am not a patent attorney, but we have patent attorneys who are specialized in each field. So we have people specialized in biotechnology, we have people specialized in mechanical engineering, automotive engineering, electrical engineering. They would be helping you with respect to the patent file, while we would be able to give you, as general IP consultants, we will be able to give you general gyan and guidance on protection of IP. So I hope that's been answered. Then there is one Prashant Kage. I'm scouting for co-founders by connecting with suitable profiles on professional sites. Everyone is interested in understanding the idea and modalities. In this case, how to ensure an idea can be protected. So that's the basic of intellectual property, and just an idea or a business model cannot be protected in India. If business models were to be protected, we cannot have Swiggy and Zomato coexisting. So only the manner in which you express the idea can be protected. Just the idea alone cannot be protected. I hope I have answered Mr. Prashant. Ramakrishna Riali, he thinks that trademark is a sham and startups can never win a dispute raised by them because anyone can put up a dispute and the legal guys keep replying, for which eventually the startup will not be able to sustain the cost of dispute. At the first instance, once a trademark is issued, no one should be able to dispute it. I think we can take this offline, Mr. Ramakrishnan. I will be able to help you get a registration if you had difficulties, but it's really not a sham. I can assure you that. I think there are numerous questions on the chat. Okay. Will this session be made available? Hello, others. Okay, thank you. For agri, one Mr. Suraj has asked, for agri product, there is any patent or not? Yes, there are numerous patents that have been afforded for various agricultural processes and products. So it depends on what product you come up with. We would have to identify whether it would come under the patent or the plant varieties. It depends on what the product is. Like I said, it has to be something new. It cannot be something that is already existing in the market. Please send the PPT to my email ID. I would request the organizers to convert it into a PDF and only share it and not the PPT
Definitely.
for
Okay.
copyright issues.
Definitely.
Yeah, and then can we get contact? Yes, I will definitely type in my email address and my mobile number before I take off so that you can reach me if there are any clarifications or doubts. Can you please share some sites where we can check patents about products specifically for active ingredients? So there is a patent search that is there, www.ip.india. I will just put the IP India address also on the chat box. That site gives you all details of how to do a patent search as well. So you can go on to the IP India online and you would be able to get the patent as well as the trademark search done. So I will just quickly put that also here. Apart from that, the Google patent tool is also is a decent to start off with to understand, to do a prior art search. But if you are planning on filing a patent, I encourage that you do a prior art search, which is something before you incur the cost of filing the patent. It is like the freedom to operate search for the trademark. This is to understand if there are any third parties who've written or who filed for a patent which is similar to your technology. So that is what is called a prior art search. Intellectual property or real property and its knowledge, its participation. Yeah, I don't think there are any other questions.
Actually, there are a couple more questions in the Q&A. So,
okay. Let me just open that.
Definitely.
Yeah. Which one is better, submitting IP owner and company name or individual here in the case of company director? Okay, so it usually whoever is using the brand, whoever is using the IP is the one who has to own the intellectual property, and it has to be consistently held. So if the company is using the trademark, then the trademark would have to be essentially filed in the name of the company. If the patent is being developed by the inventors and if individuals, the inventors can have the name as the individuals can be inventors, but it could be obtained in the name of the company. So generally, especially for startups, when you are looking at an having investors come in and so on and so forth, it is better to have the IP in the name of the company rather in the name of the individual who can still be a company director. Can I patent an active even if I'm not the inventor or owner of it? I don't understand what an active is. Anu, do you know what an active is?
Sorry.
Somebody has asked, Mr. Sumendra Kumar Naik has asked, can I patent an active even if I'm not an owner? So I would very openly discourage anybody to going and protecting anything which you've not created or you've not owned to ensure any future disputes.
So I think active is active ingredient, he meant.
Okay. Active means active ingredient. Okay, that is a terminology I think used in the agri industry. Until you have come up with something, until you are the owner, you are the creator, you cannot have that registered or protected in your name. Unless it's being done for you by somebody else, then proper credits would have to be given to that person, and then it can be protected. Anything else?
I think we have covered all the questions, Ms. Akshaya. So
okay, I will just type in my name and the contact number.
Yes. So before the closing remarks by Mr. V. Gopalakrishnan, I would like to announce the next masterclass series. So it will be happening on November 25th, and the topic is building a brand image, the art of using digital media to build a brand and reach potential customers, partners, and stakeholders. The session will be on 25th November, and the session will be hosted and the sorry, am I audible? Okay, thank you. So the speaker and other announcements will be made in the social media. Do follow our pages for regular updates. Thank you. Now I call upon Mr. V. Gopalakrishnan for closing remarks.
Good evening, everyone. It was a very nice session, and especially I wanted to thank Akshaya. I think you really made a fantastic walkthrough of what you call, first is the trademark, what are the components, Then you also covered what is the copyright ingredient which has to be there, then the patent, then there is a design, what is very, very crucial for the startups to do it. Because here again, I wanted to touch upon, because most of the time, every startup will be working with the freelancers. So they will be talking with the interns, they will be talking with the third-party tools, third-party partners. So please ensure that there are 4 set of agreements which is being highlighted by Akshaya. Like there has to be a founder agreement, there has to be NDA, there is an employee agreement, there are agreements with the manufacturers, vendors, and consultant. So don't ever compromise on any one of the compliances, because I had seen, because I would have worked with at least about minimum of 550 plus startups, and I know some crucial startups, they are facing problem because of this particular one. And the case studies which she had given, like the Achi Masala, the Talapakattu to Talapakatti, then the VIP Benz, these are all the classic example, because most of the time when you select the trademark, you are selecting a generic one. Don't ever do that. So as she said, the invented, inherited, distinct, the trademark, which is very, very crucial, like the Zomato's, the Swiggy, with there is a name which has been available. So definitely this is very, very crucial, and the trademark is only for that domestic territorial requirement. So if you feel that I have filed the trademark, I will go to US, no, it is only for India. If it is filed in India, the trademark is only applicable for India. So like you can also have a Madrid filing. Then she also differentiated with respect to what is TM and registered. So once you are making a trademark, put that signal. But when you registered and you got the registered certificate after 6 months, then you can also mention it is already registered and the trademark certificate is with you. So, and similarly, when you file the patent, you have to ensure that you are not protecting, you are not publishing any report in the public. Because many times I had seen they will make a video, they will put it in YouTube, they will also put it in a blog, and they get into problems. So don't ever do this, and ensure that you are 100%, you are keeping the patent reports, and don't make it public. So these are all some of the critical takeaway, and this session would have been very awakening for you, because learning, when you apply, then it is getting accelerated. Go to the next slide. So this is one of the things, because most of the time when you wanted to have a big with the dreams, when you wanted to win big, you have to have a lot of curiosity, because this sessions will give a lot of curiosity. Thereby you will be making a greater attitude, and be yourself, because most of the time you have a quality, you have a distinctive advantage, you are the differentiated person. So be yourself and continue the journey with a lot of perseverance and passion, so that you will be able to make your venture as one of the greatest venture, because you are giving your time, you are giving your hard work, you are giving your valuable input for at least about 3 years plus building that venture. So have a greater attitude, so that you will be making a greater venture for your company. So with that, I hand over the things to Anu. Over to Anu.
Thank
Thank you, Mr. BG, for your precise remarks. I think I would like to share the contact details of Akshaya with all the participants. So her email ID is akshaya@kriya.law, and her phone number is 9751003029. I'd like to repeat the number for anyone to take down: 9751003029. akshaya@kriya.law. With that, now I'd like to end the session with a vote of thanks, and I invite Ms. Geetanjali to propose the vote of thanks.
Hello, Akshaya. Thank you. Thank you for your brief and precise knowledge sharing. So, on behalf of the entire Samunnati family, I would like to thank her for sharing her knowledge and insights. And I'm pretty certain that it will be very helpful for the budding agripreneurs and the entrepreneurs to secure their ideas and develop their startup into a very established business. And last but not the least, I would like to thank all the agtech startups, the food sector startups, the stakeholders, our innovators, and the pool of incubators, because without them, this session and the entire masterclass series wouldn't have been possible. And I also recommend you to follow our social media handles for regular updates. And thanks again for joining us today. And we will see you next week. You can also contact us via our email ID, which is startup@samunnati.com. And you can get your queries answered via that mail when it comes to startups. We are happy to provide you additional support. And thank you for joining us today.
Can you repeat the next session?
Yeah, also the next session will be building a brand image and branding. So the name of the speaker and other such details will be published in our social media handles. And also the session will be live on YouTube also. You can watch it in there also. Thank you.
Thank you. Thank you, Samunnati, for having me. Thank you so much.
The pleasure is ours. Thank you. Thank you, Akshay.
Thank you.
So we can take
Thank
up
you, Gopal sir.
Thank you, Akshay. Thanks a lot. Thanks a lot. Thank you.
Yes, Ms. Akshaya, can you turn on your video so that?
Yeah, no, that's why I'm having some technical issues. That's why I'm not able to turn on my video.
Oh,
Yes.
that's fine.
It was nice having you. Thank you, Ms. Akshaya.
Yeah, thank you. Thank you.
Thank
Bye.
you. We were happy to have you.
Thank you. Thank you, everybody. Thank you. Bye.